law capture, and the future of the South African state. The following information is for entertainment and educational purposes only. It does not constitute any legal advice. The Republic on Trial, Law, Capture, and the Future of the South African State. Section 1. Evidence. In every constitutional democracy, there comes a moment when the nation must look squarely into the mirror of law and ask whether its institutions still serve the people or whether they have been quietly sold to the highest bidder. For South Africa, that moment is now. 5 years after the monumental Judicial Commission of Inquiry into allegations of state capture, better known as the Zondo Commission, the promise of justice has not materialized. What began as an investigation into corruption has become a test of whether the Republic itself still belongs to its citizens, or whether it has been absorbed by a covert, de facto corporate system of power. The Zondo Commission's final reports are not rumor. They are judicially constituted findings, supported by witness testimony, bank records, and internal correspondence, thousands of pages tracing a web of influence that stretched across the public sector. They revealed how state-owned enterprises, Eskom, Transnet, Denel, South African Airways, PISA, were systematically manipulated by private networks of political and business actors. Through inflated contracts, clandestine payments, and boardroom interference, public institutions became private revenue engines. Procurement laws were ignored. The Public Finance Management Act suspended by urgency. The Prevention and Combating of Corrupt Activities Act unenforced by paralysis. The Constitution itself reduced at times to ceremony. These were not isolated scandals. They formed a pattern of governance by deception, the quiet corporatization of the state. Section 2. The failure to act. The findings were handed down. The nation waited. And yet, in the 5 years since, one prosecution, and that not of the architects of corruption, but of a whistleblower. The National Prosecuting Authority, the police, and the political executive all cited complexity, under-resourcing, and delay. But the law does not allow for paralysis. Section 2 of the Constitution of the Republic of South Africa, 1996, declares that the Constitution is the supreme law of the Republic and binds all organs of state. Section 195 demands accountability, transparency, and efficiency in public administration. The rule of law is not optional. Yet the machinery of justice grinds at a pace so slow that it borders on abdication. This failure is no longer procedural, it is constitutional, and it is existential. Section 3. The de facto corporate regime. What now confronts South Africa is not a foreign coup, but a domestic conversion of the state itself, a de facto regime of corporate capture operating within constitutional form. Ministries, state enterprises, procurement systems, legally defined organs of government have, in practice, served the financial interests of private actors cloaked in legitimacy. Contracts written under the Companies Act have supplanted duties created under the Constitution. The public purse has become a balance sheet for private rent extraction. This is not theory. It is recorded in the Commission's evidence, in leaked emails, in whistleblower affidavits, and in the silence of the institutions that should have responded. South Africa remains a constitutional state on paper, but functionally, large parts of its administration now operate as commercial subsidiaries of vested interests. Section 4. The law's position. The law is unambiguous. The Public Finance Management Act makes any official who knowingly authorizes irregular expenditure personally liable. The Prevention and Combating of Corrupt Activities Act renders it a crime for any person in public office to abuse power for gain. The Constitution requires that public power be exercised lawfully, reasonably, and procedurally fairly. Yet the implementation of these principles has faltered. Enforcement has become selective. Accountability has become negotiable. When law becomes optional, governance becomes theater, and justice, a rumor whispered in corridors of power. Section 5. The cost of inaction. The cost is not only fiscal, though it runs into hundreds of billions of rands in lost public funds. The greater cost is constitutional, the corrosion of faith in the institutions meant to protect the people. Each unprosecuted act of corruption signals permission for the next. Each unimplemented recommendation from a judicial commission signals that truth has no consequence. And each new commission, convened to investigate the previous commission's findings, risks turning justice itself into administrative theater. The people have paid, again and again, for reports that gather dust, while those responsible enjoy impunity behind corporate veils and procedural delay. Section 6. The path forward. But the Republic is not yet lost. The legal architecture to restore integrity still exists. Independent prosecution under Section 179 of the Constitution. Judicial review and contract invalidation under the Promotion of Administrative Justice Act. Asset recovery and forfeiture through civil process. Public transparency via the Promotion of Access to Information Act. Parliamentary oversight and constitutional amendment where necessary. The law is ready. What is missing is political will and prosecutorial courage. In jurisprudence, there is a maxim, ubi jus, ibi remedium, where there is a right, there is a remedy. But a right unenforced is a right denied. The Constitution does not defend itself. It depends on men and women of conscience, in law, in the courts, and in public office, to act. Section 7, Closing Statement, the Republic on Trial. South Africa today stands at a constitutional crossroads. The evidence of capture is clear. The failure to prosecute is undeniable. The question before the nation is not what happened, but what will be done. The Republic is on trial, not in the courtroom, but in the court of public duty. Its verdict will not be written by commissions or inquiries, but by action or silence. In the final analysis, the choice is stark: to restore the rule of law, or to surrender it to the invisible hand of corruption disguised as commerce. History and future generations will record which path was taken. Pause. The time for investigation has ended. The time for enforcement has begun. This is the Republic on trial. If you want to get involved in efforts to make real changes in South Africa, to improve life for all, contact the South African Assembly on www.thesouthaafricanassembly.org. Striving to change the lives of all men and women in peace, truth, and love.